undermine the work done by the municipalities to influence the spatial development framework plans and the IDPs. So in conclusion, Chair, we support the city in the objection of the Eskom application. We think municipalities and Eskom are still not at an equal footing, and the more NERSA licenses Eskom areas, the less the future revenue for the electricity suppliers in the municipalities. And if there's an area to electrify, that depends on securing bulk supply from Eskom. We're not sure if Eskom will play fair, especially when that area is lucrative like this one. The question of municipal capacity to reticulate must be secondary and irrelevant here. Doesn't mean that their executive powers must be ignored in their area of supply. So basically, they must concede as a service authority that, yes, we don't think we are capable. But if they haven't considered that, you must consider all the facts on the table, including those of the constitutional powers of municipalities. I think this is just repeating what I was just saying, that the municipality must be given an opportunity to demonstrate, not just in the public hearing, but to demonstrate to the NERSA engineers the capability that they have and the plans that they have around the supply of this area. And also, basically, we maintain that NERSA must review the Eskom license to include a clause which is a requirement of a service delivery agreement between Eskom and municipality. And because you know why we say this, the second last bullet, it's because once this process is enabled by NERSA, it will actually allow municipalities or enable municipalities to be able to put Eskom to account for the revenue that they are making in these areas of supply of municipalities. So it is for this reason, obviously, that we have taken this municipal constitutional powers impasse matter to court for a declaratory order. So we're not taking Eskom to court, but we want to help Eskom with the clarity from the judge, constitutional judge, that what is in the Constitution means 1, 2, and 3 for electricity reticulation. So, Chair, this is the end of my presentation, and I thank you for your time.
Members, you have the presentation. May I just see questions, starting with yourself, Madam Massetti.
Thank you, Chairperson, and thank you, Mr. Ngidi, for the presentation. I would like to start off with the issue of the municipality having the right, or as the authority that has the right to service within its boundaries, versus the fact that the municipality does not currently have the distribution license that gives the municipality the right to service the area that is the subject of today's hearing and the application. Can you clarify us on that one? Because you're talking about just the municipality or the area or the entire city being within the constitutional right of the municipality. However, the area to service or provide services to customers in that particular area, the municipality in the area that we're talking about is not servicing those customers. So I would like to just understand if you can clarify me on that one, whether it still has the right or has the exclusive right to service that area or supply it with electricity, even if it does not have currently the infrastructure that is laid out in that particular area of Mooikloof. And also it does not have a license that covers that it can supply that area. How do we deal with that kind of a situation? Also bearing in mind the provisions of the Constitution, which actually state clearly that customers or consumers have the right to access electricity. How do we then deal with that kind of a situation if there's another service provider that then wishes to supply and provide the services to customers, the much needed services to customers, of which customers do have constitutional rights to access electricity? So that is the first question. The second question is this, that Mr. Ngiti, how do we deal with the municipality's ability to supply first, and how do we deal with what you are asking us to say, let us consider the municipality first to give the right of first refusal before we do anything as NERSA, when currently we do not have an application from the municipality. In other words, we don't have competing license applications before us, so that we can then be in a better position to do the required comparison and consider these other things that you are requesting us to do. And having said that, also, I would like to then understand whether, in your view or SALGA's view, is there any legal provision that will deter NERSA from granting the right to Eskom to supply electricity to this new area when Eskom has taken an initiative or has seen commercial opportunity and has then decided to take advantage of that commercial opportunity and service customers in order for customers then to have access to electricity? I'd like to understand what your view is with regards to that. And lastly, if I may just get your views on the fact that Eskom is talking about the island of networks, that it is trying to also, by taking this advantage, is trying to also avoid a situation where there will be island of networks. But if you look at the map there, you will see that there exist, some pockets of networks in any event. If you look at the infrastructure of Eskom and that of the municipality, there are pockets of networks that are within, and how are those dealt with? I would like to just hear you on that, because those island of networks, they already exist. Would it change anyway, even if we had an application before us and we decide otherwise? I just want to get that clear. And then lastly, Chairperson, can Mr. Ngiti clarify whether they are opposing the application that is before NERSA? I heard him saying that they support the objection placed by the municipality. That objection was during the objection stage, not at this point in time during the hearings. So I just want to understand, as an entity on their own now independently, are they opposing the application so that we can consider that as one of the independent stakeholders when we are taking a decision? Thank you, Chair.
Thank you, Madam Massetti. Members, I see no further hands. Can I also pose a couple of questions? Firstly, I'd pose the question that I posed to Eskom. In SALGA's view, what is the actual definition of articulation? How do we define? I know what is in the Act, very broad, but perhaps doesn't actually. But can we then, from the municipality point of view, if we can maybe prefer a view that may be supported by any legal opinions you may have done? That's the first question. first question. I guess linked to that, I'd like to understand, in SALGA's view, where is the boundary between distribution and reticulation? Where does distribution start and where does distribution end? And where does reticulation start and where does it end? I'm talking here, I guess, in respect of, I guess, the MVs, the LVs. If you can maybe just have an indication, because I'd assume that SALGA would probably have a view on this. What is your view on it? The third question, in your view, Hlomoga, is trading the exclusive right of municipalities in its territory? Or can somebody else trade electricity in your area? Or do you believe that in terms of the Constitution, the powers given by Section 156, does it make trading in a particular municipal area an exclusive right of a municipality in its area? Linked to that, I guess the question that I wanted to understand, I think it is the issue here about the surcharge. That do you perhaps believe that even in Eskom supply areas, should the municipalities have the right to levy a surcharge on top of the energy, capacity, or demand charges? Are you perhaps saying that perhaps a surcharge should always be clearly indicated and demarcated separately from these other charges, the energy charge, capacity charge, and demand charge, such that even if you had another trader in a particular area, that the surcharge could still be levied? I mean, use the figure of 6 cents per kilowatt hour, for instance, as your indicative number. Is that your view? Those are the questions from my side. Again, Hlomoga, as always, you have 10 minutes to respond. However, you do also have 7 days to respond in writing to those questions that you may want to further elaborate on, or any of the questions that you may not have asked. Over to you, sir.
Thank you very much, Nguni. And thank you to the panel for the questions. I think there are questions that I will answer, like number 1 and 2 from Ms. Masetti. Those questions, I will just give them a consolidated answer because they talk to the same issue. The first question was around the authority right to service, and also how do we deal with the municipality's ability to supply. I think to answer those two, there is a process that is in the Municipal Systems Act, which is called a Section 78 process. And that is linked to the service authority status of the municipality. The service authority in its jurisdiction, when there is a new development, which obviously is in the jurisdiction of a municipality, which ultimately would be a constituent of a municipality. Any municipality, according to the Systems Act, which links to the executive powers of municipalities in the Constitution, they must deliberate on a Section 78 process, which is a very iterative process that a municipality must go through to check its ability to supply that area or to service that area, and also to make a council resolution on which service delivery model is going to be used to service that area. Is it an external service delivery model, or is it an internal service delivery model? And that considers a lot of things: the ability, the capacity, and all other issues that has to do with the municipality being able and be willing to service that area. So that process must ultimately come to a council resolution, where a council will make that decision that based on these abilities or inabilities, we think we're going to do this service or provide this service using an external mechanism. And what is an external mechanism? It could be Eskom, it could be an IPP, it could be any distribution utility that might come and say and demonstrate a capability to do the service. So basically, any external mechanism that a council can resolve on. Then internal mechanism is where a city would say, we've assessed and done the feasibility of this area and our capabilities, and we think we're going to make a council resolution to use an internal mechanism. What is an internal mechanism? An electricity department of a municipality, a city power of a municipality, a SENTLEC of a municipality. That is basically your internal mechanism. So that is the process. It's linked to the Constitution and it's in the Municipal Systems Act to operationalize how the services are going to be provided. There was a question that was saying, in SALCA's view, do we think there's any legal provision that can prevent NERSA from deciding the Eskom supply, deciding and giving the Eskom this area of supply? So basically, I think there is, it's not going to be an easy thing to be specific and say this legislation or this law will impede NERSA. But I think in my presentation, I did say that the national legislation must not go against what is in the Constitution or the powers that municipalities have been given in the Constitution. So in our assessment, if the decision of Eskom and the legal advice tell us that it has not been in line, or it has not been aligned to what the Constitution says around the supply of electricity, then that decision would be challenged. So it's hard to say this is what will impede NERSA not to do this decision. It will be based on a number of things that would need to be assessed post the decision, and having assessed all the issues at hand and the facts at hand.
Can I just ask, there is a hand from Madam Maseti. I think there's a quick follow-up question. Can I just allow that, please?
Yes, sir.
Thank you, Chairperson. Chairperson, what I'm saying, thanks for the clarification, Mr. Ngidi, but what I'm saying is that even when you make reference to Section 78 of the Municipal Systems Act, I'm saying currently before us, we do not have an application by the municipality, if the municipality was interested in the area, to service customers, so that as NERSA, we can also balance it with the right for others, like customers that need to access electricity in that very same Mooikloof area. So how do we balance that, number one? And number two, how do we then tell whether this municipality has the ability to supply when the municipality has not applied to NERSA? And we do not have, secondly, we do not have competing license applications before us so that we can be able then to compare. How do we then come to your understanding on what is expected by SALCA or anyone in support of the municipality without us having that before us? Thank you, Chair.